All right, we can get started. So, good afternoon, everyone, and welcome to today's webinar. We're going to cover the ABCDs of Medicare Crash Course and Advance Directives. My name is Alida Coutinho, and I am the Network Coordinator for the Aging Services Council and the Aging and Disability Resource Center. And one of the reasons why we chose this topic is because Medicare and Advance Directives are two topics where older adults, caregivers, and professionals often have the most questions and sometimes the least clear answers. So, our goal today is to provide clarity, resources, and guidance so you can better support yourself and those who you care for. So before we get started, just a few housekeeping items. Please stay muted during the presentations, and we will have a dedicated Q&A session at the very end for both speakers. So please just hold off your questions until the very end, and you can start typing them on the chat, and we will make sure that they get addressed. So before we get started, I do want to introduce our new program specialist, Monica. Monica, would you like to share some words?
Yeah, good afternoon, everyone. Can you hear me? Nice. So, some of you know me. I have seen you. I've been around for a while. I've actually been working at the agency for almost 3 years, but my roles have transitioned a little bit and I'm shifting over into becoming the ADRC program specialist. And I'm the new chairperson as well for the ADRC steering committee. So welcome, welcome. I did send an email about 2 weeks ago out to you, and feel free to reach back out if you have any questions, or we can just work through things together. And moving forward, I have the pleasure of actually getting to introduce Miss Michelle Davis. She's one of our benefits counselors here at the Area Agency on Aging. And Michelle has extensive experience in helping older adults navigate Medicare and other benefits programs. I happen to know from working with her firsthand that she's very passionate about breaking down complex information into clear and practical steps. So we'll be hearing from a very knowledgeable person today. And Michelle, I'm going to turn it over to you. Welcome, Michelle. Michelle, can you hear us?
I think Michelle is still muted.
Oh, okay.
Here we go. Okay, there we go. Hello, my name is Michelle Davis. This isn't the right PowerPoint, but that's okay. I can use this one. Let's see. So again, my name is Michelle Davis. I've been a benefit counselor for the past 3 years, but I've been with the agency for 13. So I know pretty much a little bit about all the different programs that the AAA offers. But I just recently got into the role of a benefit counselor, assisting our beneficiaries with navigating Medicare. I myself have just joined the ranks of Medicare, so I can bring my personal knowledge when it comes to Medicare. So let's see how. There we go. So just to give an idea, what is Medicare? It is a federal program. Actually, it started back in 1964 with just basically Medicare Part A, which is your hospitalization. But in order to qualify, you do need to work for a minimum of 40 quarters or 10 years, be a U.S. citizen or legal resident. Those who are under the age of 65 with a qualifying disability can, after they've been on Social Security disability for 24 months, they qualify on the 25th month to be Medicare eligible. And then anyone of any age with a diagnosis of end-stage renal disease or ALS is automatically qualifies for Medicare. So there are 3 parts to Medicare. Part A is your hospitalization, Part B is your doctor visits, and Part D, as in drugs, is your prescription drug plan. Part C, you'll hear most people call it Advantage Plan. So Part C and Advantage plans are exactly the same thing. They are, it's managed healthcare, which is private insurance companies offer their plans to Medicare beneficiaries without an additional premium. So it also includes the Part D drug plan. So you can have, it works very similar to your group health insurance. Let me go to the next slide. The next thing, I know I'm kind of going fast over this, but I know we don't have that much time here. You can either be on traditional Medicare, which is Part A and B, and choose a drug plan. And then you can get what is a Medigap or a supplemental policy. And what those plans are is also through private insurance companies that pays the 20% that Medicare does not cover. So for example, if your doctor visit is $100, Medicare pays 80% and you are responsible for 20%. If you have a Medicare supplemental insurance policy or a Medigap policy, it pays that $20. And you can only have a Medigap policy if you're only on traditional Medicare. You cannot have a Medigap on an Advantage plan. So basically, how do you decide? You need to, how often do you go to your doctors? What type of health conditions do you have? Do you take medications regularly? Not necessarily regularly, but how many medications do you take? What is your budget? What are your preferences? Do you have specific doctors? I often tell my beneficiaries, if they're thinking about getting into a Advantage plan, to check with their doctors to see if those doctors do take Advantage plans, because I would say 99% of doctors do take traditional or original Medicare, but not all doctors take Advantage plans. So if you or your clients are considering an Advantage plan, check with those doctors to see if they do take Advantage plans. From a personal experience, my doctors do not take United Healthcare, so you may want to check with your doctors on that. So your costs, Medicare is not free. However, you do have, if you did pay into Medicare, meaning this is through payroll deductions, a minimum of 10 years or 40 quarters. Your Part A, which is your hospitalization, is free. Your Part B does have a monthly premium for 2025. That's $185 a month. It is projected to go up to, I'm not sure exactly. I know it's about $20. So it's going to be around 200 and some change for 2026. That's unfortunate. Then you do have co-pays or co-insurance. Again, there's an example, if Medicare covered expenses $100, Medicare is going to pay $80 and you pay the 20% or the $20. Advantage plans have a fixed amount, so it depends on what services. Some like for example, on the Advantage plans, the specialists can be anywhere from $30 to $45 per visit. So it just depends. So you have to weigh all of those costs. So when can you enroll? If you are turning 65, let's say, for example, if you're turning 65 in September, your initial enrollment period begins 3 months prior, which is June, and ends 3 months after your birthday, which is December. So you have 3 months before your 65th birthday, your birthday month, and 3 months after to enroll. And you enroll by going to Social Security. You can go online and enroll through the ssa.gov website. You do not have to take your Social Security at this time. Many folks wait until they are 67. But if you want to, do it all in one swell swoop, you can do that. Just know that at 65, you do have to enroll in Medicare. So I went ahead and told the steps of how to enroll. That is going to ssa.gov. Once you do that, you get your Medicare card within about 2 to 3 weeks. That it was about 2 weeks for me. Then you can, once you have that, then you can look at if you want to stay on a traditional Medicare and choose a drug plan and a Medigap policy, or do you want to look at Advantage plans? And that's where I would come in. You can call our intake line, and me and 2 other benefit counselors can assist you on finding the best plan for your medical needs, and that also suits your budget. So here's the thing, a lot of us are working later than 65, than retiring at 65. So what if you are working past 65, like myself? You still have to apply for Medicare, but you can delay Part B, which has the monthly premium, as long as you have credible health insurance, meaning you have group health insurance through your employer. You need to check with your employer to see if they do allow you to continue to be on their group health plan. Most large companies, meaning those that are 20 or more, do allow their employees to stay on their group health insurance. You can elect to just stay on Part A, which is the free premium, that's additional hospitalization, and delay Part B until you decide to retire. You do want to, if you are planning on getting onto Medicare and not stay on your group health insurance, even if you are still working, or if your employer says, no, you have to get onto Medicare, you can't stay on your on the health insurance that they have provided you, you do have to stop contributing to your HSA about 6 months prior to you enrolling in Medicare. That's not a Medicare thing, that's an IRS thing. And the reason is because because that money is not taxed. And if you are contributing to the HSA, you may, when you do your taxes, you may have to pay extra on your tax return because of that money. So you may want to check with your benefit administrator with your employer to make sure that you disenroll from contributing to your HSA. You can still use the money in the account. You just can't make that that contribution on that. Okay, so then once a year there is open enrollment. Open enrollment is mainly for those who are already on Medicare, and that is their opportunity to look at their plan, whether it's a drug plan or an Advantage plan, and to see if that plan still works for their needs. They don't have to make any changes at that time. You know, they can keep the plan. They don't have to do anything. It just rolls over to the next year. Or if you don't like your plan, this is where you can change plans, change Advantage plans. You can switch from original Medicare to Advantage plans or vice versa, or switch to a different drug plan. And that is through October 15th through December 7th. So you can make your changes then, and they will come effect January 1st of the following year. There is also a second enrollment period, which is January 1st through March 31st. That's mainly for those who want to go from one Advantage plan to another at that time. Let's say you switch during open enrollment in October to an Advantage plan, and January comes around and you don't like it. And so you do have another opportunity in January through the March to change that Advantage plan. You can always go back from an Advantage plan to original Medicare at any time. So that is an option if you want to do that as well. Okay, so here are some numbers. There's the Medicare, which is 1-800-Medicare, Social Security. I usually tell people if they are going to go to Social Security to pack a lunch and some reading material, because you're going to stay there for quite a while. Or, you know, give us a call. There's our intake line, 916-6178, or you can email us at bcinfo@capcog.org. Let's see. Okay. So unfortunately, frauds and scams are just as prevalent in Medicare as they are in everyday life. You do want to make sure that you are looking at your, your EOBs, your Medicare statements. There has been some fraudulent cases where beneficiaries are being charged on their Medicare accounts for durable medical equipment that they never asked for. One of the biggest things that in recent was insulin. We had a client that was charged for insulin, and the person was not diabetic. Well, a year or so later, she is diagnosed with diabetes, but she can't get the supplies because, one, she had prior had all the insulin and such charged onto her account, so she couldn't start a whole new one. So we had to do a fraud case on that, and fortunately, Medicare did take that into consideration so that she was able to get her medication. So that is just really very important. You want to make sure that you're not being double billed. Any unnecessary services, like I mentioned before, the durable medical equipment that hasn't been described. So you want to look at your statements. So if you do want to investigate your statements and such, always, contact Medicare. and they can help you go over that. They have the opportunity, they can look into your account specifically on that. Also, too, Medicare and Social Security will never, ever call you on the phone. If you get a phone call stating that they're from Medicare or Social Security, just hang up. And also, too, if you don't recognize a phone number, don't answer. I think most of us are pretty good at not doing that. Unfortunately, they keep switching the phone number. So once you block one, another one comes up. And so it seems like it's a vicious battle. Okay, so if you do want to, if you do suspect fraud or a scam, you do want to report it. There is an organization called the Senior Medicare Patrol. They are a wonderful organization, and they have been at the forefront of fraud. Unfortunately, Medicare fraud is a $5 billion, and that's B as in boy, dollar issue. And it's bigger than most people think. It happens quite often. So you do want to report it to Medicare, or report it to the Senior Medicare Patrol numbers. Let's see. Okay, so Medicare, if you're new to Medicare, you do get 2 preventative services at no cost to you. One is a welcome to Medicare. Basically, it's just to kind of introduce yourself and your doctor to Medicare. It's as long as there's no diagnosis or anything, that it's free. Meaning, if you basically all they're going to do is maybe take your temperature, your blood pressure, height, weight, and just get a general idea of your medical history. And that will, that is your welcome to Medicare wellness preventative service. You also have another annual or a yearly wellness visit, which is similar to the Welcome to Medicare. They may, they're going to look to see if there's any changes and make some recommendations. And that too is of no charge to you. If they do find something and the doctor does want to make further inquiries, like maybe some blood tests or additional tests, whatever, just know that yes, you will be paying some type of copay for those services, because that's not part of the wellness. They're just basically just annually just making sure that there isn't anything serious going on. But if you do want to have a more comprehensive visit, yes, that is something that you do may have a copay for, which is not the annual wellness visit. So again, I guess I'm going a little faster than I thought here. You may want to on the Welcome to Medicare, it covers, just within the first 12 months of when you're with Medicare Part B. Like I said, it takes your height, weight, blood pressure, simple vision test. You can talk about creating advance directives at this time, meaning, and a little bit about advance directives. Those are your wishes on how you want to be treated in the hospital. Do you want to do a do not resuscitate, or do you want all the whistles and bells to keep you alive in that situation? I went over the annual wellness check. It too is helps with making sure that there isn't any issues coming up or creeping up into your life, or that if something does come up, that it can be addressed right away. That's something that we all want to make sure that we are staying on top of our healthcare, because only we are responsible for our health care. Our doctors can only do so much. So you do have to take an active role in your health care. And that's one of the reasons why it's important to have these annual wellness visits. Okay. Medicare costs. Yes, there's Medicare can be expensive, especially if you are on limited income. There are several programs that will help with this. There's the Medicare Savings Program, the Low Income Subsidy or Extra Help, the Medicare Prescription Payment Plan, and the Give Back program through Advantage plans. So the Medicare Savings Program is a state program that is run by Medicaid, but it is not actual Medicaid. It's not full Medicaid. It's just they just run the program through the Medicaid office. And what it does is it helps folks with limited income pay for some or all of their Medicare premiums, deductibles, coinsurance. There are 3 different types. As you can see, the qualified Medicare beneficiary, specified low income Medicare beneficiary, and the qualifying individual. And each of them has specific eligibility requirements. So if your income is below $1,325 for an individual or $1,783 for a married couple, it will pay not only your Part B premium, but it will pay for your Part A if you don't qualify for the free premium, the Part A. It pays the Part A and Part B deductibles, coinsurance, and copays, and you're automatically qualified for the Extra Help program, which helps pay your prescription drug costs. SLMB, the income limit is $1,583, and then $2,135 for a married couple, and it just pays your Part B premium. You can also get the Extra Help to pay for prescription costs. Qualifying individual, if your income is at below $1,781 or $2,400 for a couple, it too pays your Part B. However, that comes on a first come, first served basis, and the priority is given to those who have received QI benefits the following year. All of these programs, you do have to reapply every year. Medicaid does it, or Texas Health and Human Services is supposed to send renewal notices on occasion. Sometimes, folks, they don't really realize that that's what it is, that they have to reapply, and then we'll get a phone call saying, I don't have my QMB anymore or something. They would have to reapply again for the program because they let it lapse. So resources, basically resources cannot be more than $9,660 for an individual. This does not include your primary home or a car. But if you own property or have rental property, that is included as part of income, and you may not qualify for any of these programs. So Extra Help is a federal program through Social Security. You apply through ssa.gov, and it helps assist those with your prescription drug costs. It'll help you. If you have, if you didn't have Part D when you first enrolled and you're now having to pay enrollment penalties, it'll pay for those penalties. It will help pay not only your premiums and deductibles and co-pays, but it allows you to auto-enroll in the Medicare Savings Program if your income meets those qualifications. That. Excuse me. So here are the eligibility requirements for extra help. If you don't qualify for the Medicare Savings Program because of income level, you may qualify for extra help. Usually your drug costs are pretty expensive. It's very expensive out there. Individuals, if your income is at 1976, couples is 2,664. Asset limits is a little higher. So the asset limits for an individual is 17,600, and for a couple is 35,130. So if you have just Medicare only, it will help pay the premium. Your generic drug costs will be considerably lower, as well as your name brand costs. So if you are on the Medicare Savings Program, you're automatically enrolled in extra help. If you have Medicare and Medicaid without the Medicare Savings Program, you too are automatically enrolled in extra help. And it will help pay your premium and your deductibles. So what if you don't qualify for any of these programs? There is help out there. A new plan that just started in January of 2025 is called the Medicare Prescription Payment Plan. And basically what the legislature did was got rid of what they called the donut hole, that it no longer exists. So what they have done is they have capped your out-of-pocket prescriptions to $2,000. And how it works is that you enroll through your drug plan or your Advantage plan, and it spreads out your prescription drugs, your out-of-pocket costs over the span of 12 months. So if you divide 2,000 into 12, it comes roughly about $167 a month. And every year, you have your deductible. So come January, you get your prescriptions, and maybe you're going to be paying like thousands of dollars come January. We just had the holidays, so you did Christmas, and so that it can be pretty expensive come January to pick up your prescriptions. What this payment plan does is that it will spread your payments so that when you use this payment plan, at least your first month will be $167. It may be a little more or a little less depending on where you are in paying your drug deductible. But it spreads it out. So what they do is that they will bill you kind of like, think of it as like your utility bill. You get a monthly utility bill, and that's what this payment plan does. Your drug plan or your Advantage plan will bill you on a monthly basis for your prescription drugs. So when you go to your pharmacy, then you don't pay at the pharmacy. You have this, you pay through your drug plan on this, and it helps tremendously. I think if you don't have the funds to, especially at the very beginning of the year, you have your drug deductible to meet, and those a lot of those prescriptions can be very costly, especially at the beginning of the year. So this is an option. You do have to re-enroll, although they may change that. I don't, they have been talking that you'll automatically be enrolled every January, but that has not been a definite yet, but that is in the book. So hopefully we will know that prior to open enrollment, or at least before January, to see if those folks that have been on the payment plan this year will automatically be enrolled for 2026. And you can enroll in this plan at any time during the year if you wish. The next program is what is called the Give Back program, and that's really for those folks that have Advantage plans. And there's only 4 insurance carriers that offer the Give Back program. That's Devoted, Humana, United Healthcare, and WellCare. And basically, what it does is it will help pay your Part B premium. It doesn't actually pay drug costs. It may not pay all of your Part B premium, but it can pay up to $175 a month, depending on the plan. So if that's something that you or your clients are considering, you may want to look into those plans to see if that is a good fit for you, not only for your health care, but also to help pay that Part B premium. So those are the programs that offer assistance. And I think that's it for me. I know that's a lot to digest in a short period of time. I'm sure I have a lot of questions, but I'm sure we can get those answered after everyone has presented. So thank you very much for indulging me, and I hope here is my contact information. If you want to reach out to me specifically, my direct line is there at 512-916-6055, or you can always email us at our intake email at bcinfo@capcog.org. So thank you very much.
Thank you so much, Michelle, for such an important information. I know a lot of you guys have probably a lot of questions. I just remind you to please hold it off until the very end. We'll have a dedicated session for all the questions that you have. Right now, I'm going to introduce to our second speaker, Paul Zambie. He is a managing partner at Texas Legal Services Center.
Okay, well, thank you very much, Alita, for the introduction, and thank you, Monica, for inviting me, and thank you, Michelle, for an always wonderful PowerPoint, very informative. And make sure I can advance this myself. Okay, wonderful. My name is Paul Zambie. I'm an attorney, managing attorney over at Texas Legal Services Center. We are a legal aid. We have about 12 different programs, and at the end, there's going to be a little page with our contact information. The program that I deal with mainly is the Legal Hotline for Texans. So we can help anybody with Medicaid and Medicare questions, or folks over 60 years of age and older on another range of documents and information. So I deal a lot with the estate planning, the wills and trusts, the advance directives, and powers of attorney. There we go. So powers of attorney. Everybody in here should have 2 powers of attorney. Texas has 2 of them. You need them both, okay? There's the medical power of attorney and the durable power of attorney. As far as medical, that's what it implies, everything medical. You know, where do you get your treatments done? The durable is really the financial power of attorney. So that deals with your more money stuff, okay, and your more possessions. Every power of attorney has a principal and an agent. The principal is you. You're the one who is designating somebody else to make these decisions for you later in life if something happens to you and you can't do it. So you've gotten dementia, you've had a stroke, you are in an accident, something along those lines where your body is here, but your mind is not quite there, capable of making those decisions for you. Powers of attorney can be either special or limited, meaning that let's say that you are in the military and you're going to be out for 6 months out of the country. Well, you can actually designate somebody to handle your affairs during that time period, and it ends after that time period. Another thing is, let's say that you cannot make it to a house closing or signing or something along those lines. Well, you can actually designate a power of attorney for just a special event. Everybody who fills out one of these needs to choose carefully who their agent is. These folks are going to have a lot of power over you and a lot of the decisions that they can make for you in the event that you cannot make them yourself. Powers of attorney can be revoked, they can be changed, and last one in time rules. A big thing is that the powers of attorney die with a person. I deal with a lot of estate planning, so I get that call all the time. I don't need a will or a trust, Paul. I don't need to handle any of that. I've designated somebody as my power of attorney when I pass away. No, as soon as you pass away, that power of attorney is no longer good, so you have to do something else. So on the general durable power of attorney, again, this is the financial one. It gives your agent a right to do many things. You can transfer titles to car or property, open and close bank accounts, CDs, enter safe deposit boxes. That's a big one. You can invest money, pay bills, file taxes, purchase life insurance. The only things that you cannot do with this, and they do, name these specifically, you cannot give away your right to vote. Okay, that's you. Nobody else can do it. An agent under a power of attorney is not supposed to make a will. So they just, I guess, assume that that's rife for abuse and that they will make a will, leaving everything to them, excluding others. Okay. And if the person who is the principal in a power of attorney just happens to be a guardian over somebody else, a ward that was appointed by the court, and they've been appointed as guardian, just because you give somebody your power of attorney for your affairs does not mean that transfers over to the other person who's named in the guardianship. That would have to go through the courts, and a judge would have to assign a new guardian for that. Okay, but otherwise, very, very useful document. The medical power of attorney. This is your kind of base thing, your everyday decision-making ability for medical issues. You can access medical review, medical information, although we do suggest that people also fill out a separate HIPAA form, but just in case, but this will handle that. You can consent to treatment, refuse treatment. If somebody is getting treatment, you can withdraw that treatment. And again, you have a lot of power over somebody. So again, be careful who you choose. Just like the durable power of attorney, where it allows some things, but other things it does not allow. The agent cannot consent to voluntary mental health services. So, a judge, if they see fit, they will put somebody in a mental home or mental institution. Some people check in voluntarily because they just feel that they need those services. A person under power of attorney cannot make their principal go in there, okay? If they say no, they say no. The power of attorney doesn't give them the power to kind of override that. only a judge can force you to go into a mental institution. You can do it voluntarily, but as far as forcing, power of attorney will not do it. Has to be done through the courts. You cannot consent to somebody getting a lobotomy, taking away part of your brain, which, you know, decreases further your thinking capabilities. In Texas, you cannot consent to an abortion for somebody. So you cannot make that decision that somebody else gets an abortion. And a big thing is you cannot neglect the principle. I've had that call many times. Paul, I'd like to do something. My brother has power of attorney over my mom. I went to visit my mom the other day, and she's not being fed. She's not, you know, she's not being changed. She has bed sores, just whatever it is. They're not doing the right thing. And the brother will say, hey, leave me alone, get out of here. I have power of attorney. She gave me power of attorney. I get to say what goes. You're not allowed to do that. That's neglect of the principle, and that morphs over into an APS, an Adult Protective Services issue, who have kind of like the power of police and the courts many times, and they can kind of make these decisions. But you cannot neglect a principle just because you have power of attorney. In general, the reason that people need their powers of attorney, and again, they're easy and free to do. There's these statutory forms out there. They're easy to fill out. You need to do them. But the biggest reason to do them is that can avoid potential guardianship. So let's say somebody didn't do anything and they're in an accident and they're in a coma in the hospital. Well, who makes decisions for their medical and their financial? Many times a judge will, and the courts will have to get involved. Hey, this person, you know, didn't assign anybody, so we're going to assign a guardian to this person to make sure that their needs are met. Guardianships are expensive. I mean, if there's the family involved that has to do that because somebody didn't do powers of attorney, and we always quote $6,000. We don't do them ourselves, but we just think that that's what other folks charge, and that's what we've heard in our community. But somebody loses their right to be an individual. They lose their legal identity. But, you know, with a guardianship, they're just very, very involved. And if you can skip that, you want to do it. Another thing is that words are going to trump a power of attorney. So an example there is, let's say that an elderly woman gives her son power of attorney for finances, you know, the durable power of attorney. And the guy drags the mom to the bank and says, hey, Mr. Banker, I want to take out mom's $20,000. I've got power of attorney and I want to close the account. And the mom says, no, I don't want that done. Son says, no, I've got power of attorney. You got to listen to me. The mom's words are going to trump the power of attorney. Okay, so that's kind of a built-in safeguard there. I already talked about powers of attorney dying with the person, so they can be used for kind of health and certain financial planning, but not estate planning, because that's what happens after death. They cannot do that. One thing, Michelle is a benefits counselor, and I know several other folks over at the area agency and possible ADRC. They are actually trained to fill out some of the advance directives, okay? The durable power of attorney, the financial, is not considered one of those, but the medical power of attorney is. So they're kind of trained to do things like that. When I said that the forms are kind of easy and free, well, over at hhs.texas.gov, that is where you can find these forms, as well as a lot of the other forms that I'm going to be talking about. On powers of attorney, we get calls from Spanish speaking people a lot. And on the website and what exists, there are some forms written in Spanish. We tell people not to execute those, not to do the ones in Spanish. Even if you're Spanish speaking, you don't read or write English at all, you want to read the Spanish form. It is there to see what is in the power of attorney, because it mirrors the English one word for word. So somebody who doesn't have any English language skills reads the Spanish one, but then they would go ahead and sign the English one. Okay, there's that for the medical power of attorney and the durable power of attorney. The reason that you wouldn't sign the Spanish one is that, you know, you're going to be submitting this to doctors, bankers, whatnot. And if those people don't speak Spanish, that form is not going to be worth a whole lot to them. So execute the one in English. People can actually study and review the one in Spanish just to see what they're signing in English. Okay, so I told that the biggest reason to get powers of attorney is that they avoid guardianship. Yeah, I mean, with a typical guardianship, an attorney has to file with the correct probate court. Hearings are set. A judge is going to review the application. A doctor has to make a report saying whether or not the individual is competent or not. A judge reviews that. A judge appoints a guardian, and then that subject becomes a ward of the court and of the guardian. So again, you're losing all of your independence. And, you know, sometimes people are sick or they're out of the country, whatever, and those powers of attorney are great. Sometimes folks get better and then they can make decisions for themselves. If you do guardianship, it's almost a no going back type thing. In order to get back your rights, you'd have to petition the court again. There are two types of guardianship. There's guardianship of the estate, which is all of your money, your property, things of that sort, as well as guardianship of the person, which is your medical things. So it kind of tracks the powers of attorney. You have the medical power of attorney, that would be guardianship of the person, and then you have the durable power of attorney, that would be guardianship of the estate. One very important advance directive is called a designation of guardianship before need arises. So let's say that you just want to be on the safe side. You're actually allowed to fill out this form and say who you would want to be your guardian. It may be the same person that you've chosen in your power of attorney, because that has to be a trusted person. But you can actually name the adult who you would like to take care of you in case that need arises in the future. Just because you're signing this does not open up a guardianship. It's just that if people in the future start to fight and a guardianship is filed in court, then this document is presented to the judge as evidence of your wishes when you were still mentally competent. Okay, so a great thing about the form is that you can name who you want, and a judge 95% of the time is going to choose that person. The only time he may not choose that person is if this was done 20 years ago, you've named your son or daughter, and then that son or daughter has become a bad egg. They have neglected you, they are abusing you, whatever it is. They're not the person who has your best interest in mind. And a judge will say, no, you've had Adult Protective Services called on you for several times in the past years. I'm going to appoint somebody else. Okay. And a judge will then look for the next best person. The neat thing about this form is that there is also a space for you to write in who you do not want to be your guardian. So let's say that you already know that your son or daughter is going to abuse you, neglect you, take advantage of you, whatever it is, and you just don't want them to have anything to do with you. Well, a judge may not know that if nothing else is written. So he may just say, well, does the person have any family? No spouse? Okay, no parents? Okay, oh, the kids. Well, we'll assign one of those. Well, you can actually fill out this form and say, nope, one or both of my kids or whatever it is, I do not want them to be guardian. And then the judge will go somewhere else. So that is a neat thing. A common theme for all of the documents that I'm going to be talking about, whether they be the power of attorney, the advance directives, the other things I'm going to go over, they can all be revoked, and last one in time will rule. So again, if you did something 20 years ago, you do one now, that's it. And if you revoke it, that is perfectly fine. Talking about revocation, though, let's say, for an example, you have one of the powers of attorney and you have had the bank accepting that power of attorney, and you are making withdrawals and deposits for your mom, and you've been doing so for the past few years. So the bank knows you, they know that power of attorney. Well, let's say that something happens and mom or dad fills out the form and revokes your power of attorney. Well, that's great that they did that, and it is going to become effective, but does the bank know, or does the doctor know you've done that? So You not only have to fill out the form, but you have to communicate that and give them the revocation saying, I do not want this person to have power of attorney over me anymore. Otherwise, bank's been relying on that for years, and they don't know that something else has existed. So just FYI that if you revoke any of the advanced directives that we're going to talk about, the powers of attorney, whatever, if there is a revocation, you need to communicate with the person who's been accepting that it is no longer valid. Okay, so we have had the medical power of attorney, which we talked about, which is kind of your everyday medical situations. Where does mom or dad go for treatment? Do they get the flu shot? Do they not get a flu shot? This and that. Kind of your normal everyday things. This is the next step above regarding a person's body and their medical treatment. So it's called the directive to physicians. A very common term is a living will. I don't like that just because when you say the word will, you just assume that you're leaving something. Well, this is not that. This is the living will. So these are instructions to medical personnel. And the normal example here is if you are in a coma in a hospital, you might be in a vegetative state or not, and your kids are wondering what they need to do with you. And, do they continue or not continue? So the purpose of this form is to inform the physicians whether you do or do not want life-sustaining procedures if you ever, unfortunately, find yourself in that position. It is for those conditions which are defined as either terminal or irreversible. Terminal is a condition where a doctor has said that you're not supposed to be living past 6 months. Okay, that's a terminal condition. An irreversible condition is something that you can be treated for, but you can never be cured. So they are for terminal and irreversible conditions. As with the medical power of attorney, this one should be made part of your doctor's records. Okay, again, you just, if you fill it out, great, but what if it just sits in your desk drawer at home and nobody knows about it? So you may want to tell your family, give them copies, but your physician, your doctor should know about this, and it should be a part of their records. Same thing here, words are going to trump the living will. So if by chance you are able to communicate somewhat and your son or daughter is making a decision that you don't agree with, well, your words are going to trump it. Let's say that you choose in this living will, I don't want any treatment to keep me alive. If I'm in this state, I want you to just let me go and let me pass. Doctors can get in trouble sometimes if they let people pass. So this gives them the permission, and then so a doctor will not be prosecuted for aiding suicide or mercy killing or anything like that. So it is also a protection for the doctor. So we had the lower level medical power of attorney. Where do you get the flu shot? Which doctor do you go to? The next step up, the directive to physicians. That's for more serious things. When you're in the hospital, you have a terminal or irreversible condition. This is the top line. So this is the nuclear thing here. And this is called the do not resuscitate, the out of hospital do not resuscitate. This is to inform medical personnel, again, whether you do or do not want this life-saving procedures. Because again, doctors in hospitals, EMS persons that come out, which is mainly the people who kind of rely on this, the DNR, they have a duty to revive you. That's what they're there for in the absence of any other communication. So why would you fill this out? I'm 94 years old, and if you do give me chest compressions, I'm going to get broken ribs. There's a whole host of reasons where you may not want to be revived. But this is for those most serious things where you're experiencing respiratory arrest or cardiac arrest. The words arrest means stop. So cardiac arrest means that your heart isn't having trouble beating, your heart has stopped beating. Respiratory arrest, your lungs aren't having trouble breathing, they have stopped breathing. So again, the medical personnel, the EMT, the EMS person, their duty is to revive you unless you direct them otherwise. And the question is, well, how do they know if something exists? Well, a few things. This may not be the first time they've come out to Mr. or Mr. Jones's address. Maybe this is a monthly thing and they know about them. A lot of people put this on their refrigerator. There is jewelry that is sold, whether it be necklaces or bracelets or something like that. And the EMTs are trained to look for those things. And there are certain companies that will say, hey, this badge means this bracelet means this. And again, these cover the most serious of things, CPR, defibrillation. I think that's those machines where you go clear, tracheotomies where they have to cut something in here to create an airway for airflow. While all medical advance directives should be made part of your doctor's records, this one not only must be made part of his records, but an individual is not allowed to fill them out themselves. This is one that is so serious because it does involve life and death that a doctor has to complete part of it. So, an individual just can't do it and then sign it in front of a notary. Doctor's got to complete the other part. This involves life and death. An advance directive that a lot of people don't think about, but I want you to know that it's out there. It's called the Supported Decision-Making Agreement. So what this is it recognizes, short of guardianship, a less restrictive substitute for adults with disabilities who need assistance with decisions regarding their daily life, but they're not considered incapacitated by the court. So let's say that there was a guardianship filed and a judge looked at a doctor's report and the doctor says, look, they have some developmental disabilities or some cognitive issues, but they're not incompetent. They can make their own decisions. So, this may be somebody with Down syndrome or something like that, somebody who may not be quite 100%, but they are not to the level where a judge is going to say that they're incapacitated. So it's those in-betweens. And a lot of times this is used for people who are turning 17 into 18. So a mother or parent has the right to get all the medical records from the child, make all the decisions when they're 17 and younger. Well, when they turn 18, they might have Down syndrome. They're 18 now. And if they haven't been declared incapacitated, a parent is just not allowed to get their medical records or make these decisions anymore. So this is something that you can fill out. It is a contract between the parent and the child. And what it does is it allows the parent to give advice and counsel on where the person with disability wants to live, what medical care they get, who they might want to live with, where they work, things of that sort. It is called the Supported Decision-Making Agreement. It's not surrogate. Surrogate means that you're replacing that person's decision. So the person who is the supporter, they can give advice and counsel, but they can't make decisions for them. So if the person who signed it, the one with developmental disability, says, thank you for the advice, I don't want to abide by those decisions, they don't have to. So it's just something where it gives the person, the supporter, the ability to access these medical records and different things, work records, as long as the person who signed it, the one with disabilities, doesn't disagree. So they're helping, but they're not replacing their decisions. And again, the form we put in there where you can find it, most of these are in the Texas Estates Codes, the form that I'm talking about. This one happens to be in section 1357. Another similar form to this, and again, because I know these folks in here are caregivers, and you may be like grandparents raising grandkids or things of that sort. So anyways, the Chapter 34 statutory form is the authorization agreement for voluntary adult caregivers. So let's say that a mom or dad obviously has the rights over their child. They may be going to prison. They may have a sickness or whatever. And so they use this form to actually designate somebody else who they obviously trust to make those decisions for their minor child. And as of 2017, before that time, it was only a very small slice of people who could do it. Immediate family members, grandparents, things of that sort. After 2017, it is any adult caregiver, so it doesn't have to be related. But again, you're authorizing somebody to make these decisions for your child on a temporary, hopefully, basis because you are unable to do so for some reason. There's no court involvement. You can actually just do this form. It remains in effect until you say no. And obviously, if there's two parents, one parent just can't do it unilaterally. You have to inform the other parent. But what this can allow to do, giving the power away to an adult for this minor person, you can consent to medical treatment, get insurance, enroll that child in school, daycare, extracurricular activities. You can help them get a driver's license or other state ID, help that person get a job, apply for public benefits for the child, get copies of birth certificates and security cards. Obviously, this is a state form, so it has more power on the state level with things like Texas driver's licenses, IDs, and birth certificates. Security cards, that's more federal. This has some weight to it, but you may have to check with the federal authorities whether or not they're willing to accept this. Again, certain things you cannot do with this. It does not authorize this non-parent to consent to an abortion or any emergency contraception in Texas. And onto my last form here. So this is a neat one. Sometimes we just don't have those difficult conversations with mom or dad, and that's what a lot of these advance directives are. What would mom or dad have wanted to do? They're in a coma in the hospital, in a vegetative state, or whatever it is. Are they going to wake up? Are they not? You're asking me to make that decision to pull the plug or not. What would mom or dad have wanted? That's what really all of these are. I mean, they do help the person during their life, but again, these die with the person. So, and when they can't make decisions and they can't inform you, what a burden that is for that son or daughter. What I have to make this huge decision. And sometimes they make the right one, sometimes they don't. But these forms are going to tell the person really what mom or dad wanted. Okay, so sometimes you don't have that conversation. What do we do with the body upon death? Okay, so this one, the appointment of agent to control disposition of remains, you can actually write down, hey, did mom or dad want to be cremated or buried? Did they want a funeral? Well, this is where it tells you about that, okay? And they can write down what they want done, and they can get very specific. You can name a second agent, a third agent, just like in all these forms, in case the first one passes away, is out of town, doesn't want to perform under this. So the last document in time rules. But again, a typical thing here is I want a funeral, I want it done here, I want to be buried here. This is who I want invited to the funeral. This is who I don't want invited to my funeral in case Aunt Peggy wants to dance on my grave or something like that. You can just kind of control what happens, and you can appoint an agent to do that. Couple things about advance directives in general. Again, they're for you, but it is a gift to your family that you have done these. I get that call a lot of times also. Hey, my folks just moved from Maine, or they're going to move to Florida. If they're moving here from Maine, they already did all their advance directives over there, and they have their powers of attorney, and they're living well from there. Just because they're moving in Texas, do we need to do a new one? Here's the deal. Texas does recognize other states' advance directives and powers of attorney. It's called the full faith and credit clause, which is great. But any state you move to, you need to do their specific forms. Okay, there may be certain little idiosyncrasies or little caveats in them. Like, for instance, a lot of other states have what's called a general power of attorney, and that's great. But that general power of attorney is only good while you're still mentally competent. It ends if you become mentally incompetent. Here, ours is called the durable. The word durable means that it survives incompetency. No power of attorney anywhere survives death. They all die with you, but ours is the durable. So that's when you want it. You want these documents to survive when you can't make decisions. That's the whole reason for them. But certain ones in other states don't have that language. So if you come to Texas, do the Texas ones. If you go to another state, have your folks fill out those forms from that state. Okay, but again, all advance directives are a gift to your kids in addition to other things. Just wanted to tell you a little bit about Texas Legal Services Center. We are not one of the big three legal aids who have literally split the state into thirds. We like to think ourselves as the fourth one. We have one office in Austin, but we handle the entire state, all 254 counties where the others don't. All of our programs speak Spanish. We have about 12 programs. Mine is one. It's the legal hotline for Texans, Medicaid, Medicare issues, a lot of estate planning issues, landlord-tenant. But we also have a very robust and strong veterans program. We have a victims of crime and sexual assault program. We have what's called the pensions right program. If you worked for a company 20, 30, 40 years and they went out of business, moved out of state, they say they don't have your pension. It's probably still out there. We actually have a couple bulldogs working in there who can recover money for folks. The people in our crime victims and sexual assault, they can actually go to court and get protective orders for folks. We have a family helpline where you can ask issues about custody and things of that sort. And again, we have our housing project, which deals with landlord-tenant issues. These are those numbers for there. Again, I'm on the top right, the legal hotline for Texans. That is my number. If you have any questions that go past this, you may have something more personal than what we're going to handle here, you can give me a call. Again, I deal with advance directives, a lot of the estate plannings, wills, trusts, transfer on death deeds, things of that sort, to see what's best for somebody. And that is it. Thank y'all for letting me present today.
Great job, Paul. That's always great information. I know that we've probably got quite a few questions. Just wanted to open it up at this time for questions for either Michelle or for Paul. And we'll go from there. I did see one in the chat that Alita did drop. If you didn't see that, Alita dropped in the chat the medical power of attorney forms. She included the link there that you can get to very quickly if you're looking for those forms. And then we did have a question from, she's had her hand up, Miss Chamberlain, Miss Donna Chamberlain. I saw you put a question in the chat.
Yeah, you can just read the chat question.
So Miss Chamberlain.
Is there an income level on the give back program?
And that would be for Michelle.
Want to know if there's an income level for the give back program? No, that's why it's for those folks that do not qualify for the Medicare Savings Program or LIS, which has income requirements. The give back program, no.
And Michelle, I wanted to ask you also, when you were going over the guidelines, the income guidelines for the Medicare, are those guidelines before taxes or after taxes?
Before any deductions.
Okay, perfect. That's what I wanted to know. Thank you.
Mm-hmm.
I believe Patrice has a question, if you would like to unmute yourself.
Yes, good afternoon, everybody. I just wanted to know if the slides will be emailed out, or is there a way we can get a copy of the slides? Because this is pertinent information, and I work amongst the homeless population and in a 55 plus community, and I would love to have this information on hand so I can refer back to assist my clients.
Yes, the slides will be emailed back to everyone as well as a link to where you can rewatch this via YouTube as well.
I see two questions for me. I'll just read them out here. Do you have to be over 65 to receive services from Texas Legal Services Center? All of our 12 programs have different eligibility requirements. My particular program, either Medicaid, Medicare, any age, because sometimes you have that when you're younger, depending. For the estate planning, it's 60 and older. We have no income requirements. Most of our programs, like our veterans, you have to be what's called 200% of federal poverty level. So you can get onto our website, tlsc.org. In fact, I'm going to write that in the chat here, tlsc.org. And you can read about all of our programs and see the eligibility for them, okay? Because some are income-based, ours is age-based. That's it. The next question is, does a medical power of attorney have to be notarized, or are 2 witnesses sufficient? So it's weird. On the durable power of attorney, the financial one, there's no room for witnesses. That needs to be notarized per the statute. On the medical power of attorney, you get to choose. You can either have it notarized, or you can have it witnessed by 2 people. And there's certain rules about who can be witnesses, but you don't have to have both. You can choose either on the medical power of attorney.
And then there is another question. What can we tell our clients on Medicare to ensure they're not being referred to unnecessary medical procedures?
That they're not being referred to unnecessary medical procedures. That's a really good question. That's not something that I have come across.
Is that like an
that
adult protective services issue, or?
Marcella, would you like to elaborate a little bit more on your question?
Yes, so this is basically from the slide from earlier about fraud and scams. That was
I see.
Yes, one of the ways in which insurances get billed for unnecessary medical procedures.
Oh, okay. So, well, right. So if you feel that you have been, that's why it's important to look over your statement and to see if there was anything that was billed to you. First and foremost, if it looks like something that a procedure that you had or have had done, check with your doctor's office first to see if they had added any other procedures. Most 9 times out of 10, they did not. Then if that is the case, then contact Medicare and let them know that, you know, my doctor did not prescribe this or did not do this procedure or anything like this. They would have to start an investigation on that, because that could be possible fraud. Yes. That's why it's really important to make sure that you look at those statements every single time. Now I know they come, now if you haven't decided to get them electronically, which you can get them electronically, you can look at your statement every month, because they only come out quarterly, paper. But if you enroll into Medicare.gov website and enroll, you can look at your statement every day if you want to. That's a really good option, opportunity to catch any fraud right then and there. Yeah, so there have been times where, or it could be a simple thing. Maybe you were billed twice for the same thing, and it could be on the doctor. The doctor may have made the mistake. So that's why you should check with your doctor first. Say, hey, I was looking over my statement and I noticed that I've been billed twice for the same thing. They need to, look into that to make sure, and what they would do, it's on them. They have to make sure that they take the steps to change that it's not being double billed. And if they don't, then that's where you would contact me and we can start the appeal and get the doctor's office to change that for you. But first and foremost is be proactive in your healthcare.
Thank you.
And
You're
then
welcome.
we have another question. I think this one's for you as well, Michelle. If someone
Okay.
still's working as independent contractor, defer Medicare Part B and register in Obamacare.
That's a very good question because Medicare and Obamacare, or they're both federal programs. If you are 60, unfortunately, if you're 65, yes, they're probably not going to let you go onto Obamacare. You're going to have to get onto Medicare, because a lot of folks, like the Obamacare because it's less on their pocketbook on some things. But once you turn 65, they'll kick you off and you have to go onto Medicare.
And then we have another question for you as well. Younger than 65 with qualifying disability after being on Medicare for 24 months, do they still need to have worked 10 years to qualify?
No, because they have a qualifying disability. It's the disability that gives them the that they can be on Medicare, which automatically, once, if they're still disabled and they turn 65, that changes things. They're now considered in Medicare because of age. I know that's an awful word to say, but that they aged into Medicare. But before, so no, they do not have to work 10 years in order to be eligible. The eligibility is having a qualifying disability for 24 months, and then on the 25th month they are Medicare eligible because of being disabled.
Okay, then we have a question regarding the Medicare Advantage plan. Is there a deduction or premium charged to the individual?
Okay, so as far as the monthly premium, there are some Advantage plans that do charge an additional premium. I don't necessarily look at those plans because most folks are trying to cut their costs. But the majority of Advantage plans do not have an additional premium. You still pay your Part B premium. You still pay the Medicare Part B premium, whether you're on traditional Medicare or an Advantage plan. They both, traditional and Advantage plans, do have deductibles that you do need to reach before the plan starts paying at 100%. But as far as a monthly premium to be on an Advantage plan, no, just your Part B, Medicare Part B premium.
Okay.
Is that clear? I know that could be not so clear. Yes, there is a premium, but it's not because you're on an Advantage plan.
I'm not sure Trace is still in here, but if you would like to elaborate more on your question or if that was clear enough for you. Okay, and then just two more questions before we can wrap up. If you get on the program that charges you $2,000 and spread across a year, but you end up spending less than $2,000 on medications, do you get any of that money back?
No. So, okay, so about the Medicare, about the Medicare payment plan, what it does is that it caps your out-of-pocket costs at $2,000. So let's say maybe maybe it's $1,500. It's going to spread out that $1,500 through the 12 months. Not, so it's going to be capped. It's just capping your out-of-pocket at, they're just giving you $2,000. So if you're the plan is really good for those who are spending more than $2,000 a year out of pocket. However, there are some folks that maybe they're really close. Let's say I'm going to random 1875. Okay, yes, I would get onto that plan even though my out of pocket cost isn't exactly 2,000, but they're going to, your out-of-pocket cost is going to be like 1875. You looked at your at the plan, and it gives you a rough estimate for that year. Then it's going to spread out that 1875 throughout that 12-month period. So
And
does
then
that
we have, oh,
does that make
so sh-
sense?
Yes.
Yes, it does.
Oh,
Thank you.
okay, good.
So Tracy actually did follow up and said, how come everyone on Medicare Part A and B doesn't have an Advantage plan?
You have to sign up for it.
How come everyone on Medicare Part A and B, they chose
Do-
not
yeah.
they chose not to be on an Advantage plan? You can have Medicare. You can take in two ways: original Medicare, which is Part A and B, and a separate drug plan. So you have your Part B premium and your drug plan premium, or an Advantage plan, which includes the drug plan, and you just have your Part B premium. Some people just prefer not to deal with an independent insurance company. That's a personal preference.
And then someone else asked that they have appealed SNF therapy care 3 times in 3 weeks. Why all the appeals?
A skilled nursing facility. Okay. I'm sorry, I'm not understanding the question.
I'm guessing they have appealed the service 3 times in 3 weeks, and they're just asking why they have to appeal it so often.
Well, my mother's in a skilled nursing facility, and she went there originally for therapy. And
Okay.
it's like I appeal because they're getting ready to discharge. And so I appeal it, and then they deny it. And then I do the level 2 appeal, and we win it. But I've had to do this every other week.
Okay, so all right, so you feel that your mother should remain in the skilled nursing facility for additional therapy. Is that why you appealed it?
Yes, that's why I
Okay.
appeal it, because she needs it.
Oh, okay. Yes. See, Medicare only allows X amount of days for you to be in a skilled nursing facility. The best thing to do is if you are the patient, or you are on behalf of the patient there, feel that more therapy, I would check with the attending physician to reevaluate and to get more therapy. I've done that with my mom. So therefore, there was no appeal was necessary. So usually, if they feel, that they're saying, okay, yes, we're going to discharge her on such a day, and you don't feel that she has adequately been rehabbed enough, then go to her doctor and say, hey, can you evaluate her to see if more therapy is needed? And then the doctor can't, usually, most likely, yes, the doctor will say, yes, Mrs. X needs additional therapy, and will do another prescription for additional therapy. But yes, in those cases, yes, you can appeal it, and sometimes you will win it. Okay.
And then the last
Thank
question.
you so much.
Oh, you're welcome.
The last question says, if Obamacare kicks you out due to you turning 65, can a senior keep her Obamacare until the end of the year, saying she was born in September?
Okay. So if she was born in September, then her Medicare will kick in September 1st. So then no. Unfortunately, because they're both federal programs, and that's considered double dipping.
Often Medicare is going to be a better deal than the healthcare.gov plan. just to keep that in mind.
All right, thank you, everyone. I know we have a lot of questions, and again, the presenter's contact information will be shared along with the slides. But before you leave, please answer the survey. We love presenting you with these trainings, and we do have a topic for our next one will be on transportation, but we will love for you to have our feedback so we can ensure we're covering the topics that you are more interested on. So thank you everyone for coming. Thank you, Paul, and thank you, Michelle, for presenting. We appreciate it.
It was my pleasure. Thank you.
Thank you, everyone. It was a great job today.
Have a great day, everybody.